So there were some interesting news reports this week about the Triller Fight Club, Ben Askren, Jake Paul piracy problems. This is the one that involves the H3H3 podcast and Ethan and Ela Klein. Now there's something else going on here. There's another lawsuit with the YourEXTRA YouTube channel, who apparently settled their case, but then the settlement was rejected by Triller and their money was returned. Let's see what Torrent Freak has to report here. They say that a lawsuit was filed in June targeting Arvin de los Santos, the operator of the YouTube channel YourEXTRA. They filed a complaint, but De Los Santos and YourEXTRA's answer was filed, and it claims a second affirmative defense. Affirmative defenses mean you did the thing, but you have a legal reason why you're not a liable party. They're claiming unclean hands, which means the plaintiff did something to invalidate their own claim. They say here plaintiffs seek equity, an injunction, but come to court with unclean hands. Defendant was enticed to settle the alleged infringement as opposed to having to go to court. Defendant agreed to sign plaintiff's settlement agreement, which sounds an awful lot like there's some kind of agreed upon settlement. Maybe that could be enforced, but usually settlements get to be enforced under contract law. So instead, this is a federal lawsuit brought by plaintiffs. So attorney Steve Vondran of California has filed this answer as an affirmative defense, and this defense as an affirmative defense, instead of, I guess, bringing a contract enforcement claim under state law. Apparently, they paid the required fee, which was supposed to come with a release of claims, but plaintiff filed this lawsuit anyway, returned the settlement fee, didn't pay any interest on the fee, which that could be key, that they accepted the settlement because they returned the fee and there wasn't any interest included. So they still have some of the money held in constructive trust, and now seeks to recover damages and attorney's fees that they are not entitled to. This is also a deceptive act and practice under California law. So I think that's a great defense there, Steve. That's weird enough that Triller would purportedly, allegedly agree to a settlement, or maybe they make a settlement offer and then the plaintiff returns it. And I'm not even sure how this was made. I'm sure we'll see more fleshed out in that case. My best estimate is that it's based on this, that Triller offered amnesty. I'm guessing that YourEXTRA paid this $49.99 amnesty settlement, which is listed here. It says something about April 23rd, Triller Fight Club filed suit against parties who participated in the unlawful sale, distribution, or viewing of the Jake Paul v. Ben Askren fight. Each of these parties may be liable for up to $150,000 in fines, penalties, and damages, which is the maximum under copyright law, but I always hate using that, and I'm always skeptical when parties say you could be liable for $150,000 in fines. They don't know that you're liable for that. The judge has to decide that. But yeah, the law does say that for the worst kinds of willful copyright infringement, $150K is the top, sure. So they're saying for a limited time ending June 1st, 2021, those individuals who unlawfully viewed or displayed the event but were not otherwise involved in its illegal sale or distribution are eligible to receive a one-time settlement and release for their unlawful acts, subject to providing the information requested below and making a payment in full of $49.99 US via this portal. So I'm guessing that YourEXTRA and De Los Santos made the $49.99 payment, but are otherwise accused of the sale or distribution. And I'm gonna guess that the response from Triller Fight Club will be that they weren't allowed to achieve amnesty or release of claims if they were not qualified to seek amnesty in the first place. Only those individuals who unlawfully viewed or displayed the event but were not otherwise involved in its illegal sale or distribution are eligible to receive the one-time settlement. So I'm going to say that's a precondition or a condition precedent to the settlement contract. I bet that's what they're going to say. Let me look at this answer again. It was filed October 18th, so I'm guessing that we don't have a response from YourEXTRA yet. indeed, there is no further response or motion, which I'm guessing is going to be a motion to strike the affirmative defense of unclean hands. That sounds like what will happen there. But that's not all. Triller is also accused of some really interesting stuff with the H3 podcast. Apparently, the H3 podcast offered Triller $25,000. Triller came back with a counter offer of $900,000, but asked the H3 podcast to publish this statement below. And this is where it really gets weird. They wanted, according to the H3 podcast, I don't have a source to test the veracity of this image, but I'm assuming that this is an image of a cease and desist or settlement communication from the Triller Fight Club lawyers to the H3 podcast. And if this is true, what it says is that the H3 podcast was asked to make a payment of $900,000, but then make a public statement that's a little bit different, maybe even a lot different. The public statement was meant to say, this is coming from the H3 podcast, "We are pleased to announce that we have reached a settlement with Triller Fight Club as a result of us pirating the event." So they, I guess, admit pirating the event. Triller surprisingly has embedded watermark technology unlike anything we've seen to date. More on this in a moment, but I don't think that they had this watermark technology that's more than anything we've seen to date. They asked the H3 podcast to then say, "We had to pay millions to settle in order to avoid $50 million or more in potential liability. We encourage anyone who pirated the event to take Triller's amnesty offer very seriously and pay the $50 before what happened to us happens to you. Triller is incredibly serious about this, and we do believe they will find most, if not all, of the people who pirated." That's a really weird statement to make, and it comes up against a legal question. Can you demand, as part of a settlement, that the settling parties, that the opposing settling party pays X amount of dollars, but says that they paid Y amount of dollars? That they paid something different? Isn't that asking an opposing party to make some kind of misrepresentation, to lie in their public statement? I can understand little white lies like, "We are pleased to announce we've reached a settlement," when you're not pleased to announce you reach a settlement. That's immaterial. But if you say, "We had to pay millions of dollars to settle," when you didn't have to pay millions of dollars to settle, 900,000 is a lot of money, it's almost $1 million, so you had to pay $1 million, would be much closer to reality. So take the S out. We had to pay $1 million to settle. I would be a little less skeptical. But if you're saying we had to pay millions to settle, it sounds to me like you're trying to use that announcement to coerce or pressure others into paying this $50 settlement, which sort of betrays the underlying motive or the underlying likelihood that you'll actually be able to pursue these hundreds of thousands of people who have allegedly pirated the thing. Also adding that they have surprisingly embedded watermark technology unlike anything we've seen also sounds kind of pressuring or coercive. But that's sort of a statement of opinion. We are surprised about the embedded watermark technology. What I would like to have seen is that Triller uses individual watermarks so that those who publish the video illegally, you can trace it back to a source and then go after the source of the illegal transmission. That's what I understand Apple does with iTunes Music. There is some kind of unique identifier for your account embedded in the music that you get, and then Apple can trace it back to the source whenever they find piracy. I could understand that with pay-per-view events like Triller Fight Club. I'm guessing more like they have not individual watermarks, but a general watermark, one watermark for the whole thing, so that they can use a sort of content evaluation system, a content ID system, a content ID-like system, to evaluate whether videos match something from the fight or not. That sounds more like it. I don't think that that's watermark technology unlike anything we've seen to date. But that's not my real problem. My real problem is saying we had to pay millions to settle when you didn't have to pay millions to settle. I could see someone then settling and then later on feeling like they relied on that statement to their detriment, which would be something called detrimental reliance. And now I'm not entirely sure about this legality. Is this legal or not? Is not something I was able to quickly find in contract law. Apparently, there aren't many fights over making false statements as part of a settlement. The parties are usually interested in walking away, and other people, how are other people really in privity, in legal connection with this contract and this public statement? It's kind of complicated. So I can see why Triller thinks that they can do this and there wouldn't really be fallout from it. But it's weird. And my first issue spotting with it is, would that provision in a settlement agreement be enforceable? These settlement agreements often have severability clauses where if one of the clauses is found to be invalid, that just gets invalidated and thrown out, and the rest of the contract is valid and doesn't contaminate the whole contract to the point that the whole contract is void or voidable. So if the H3 podcast paid the $900,000, everybody signed the agreement, and then they refused to make the false part of the statement, I don't know how enforceable that is. Could a court really enforce a contract to make a false statement? And my initial thought is I don't think so. But I admit this is a very gray area of law for me, and I would look forward to hearing from maybe some more experienced attorneys in the areas of settlement contracts. I do a lot of settlement contracts, but it's the same settlement contracts, and we certainly don't have false statements in our settlement contracts. So I'm kind of torn as to how strange this is, and I'd love to hear your thoughts in the comments below. I will also link to the H3 podcast where Ethan talks about this, in case you would like to watch that segment. Ewan thinks $25,000 was way too high. Yes and no. Maybe a reason why they offered $25,000 is because they are going to spend more than $25,000 defending themselves, and there is some kind of uncertainty whether the judge will grant the shifting of attorney's fees. You don't automatically get attorney's fees. Even a prevailing party in a copyright suit who can get attorney's fees, it's up to the discretion of the court, and there is Fogarty versus Fantasy, which is a case all about fee shifting. And we saw from the Akilah Hughes versus Carl Benjamin case that fee shifting, the plaintiff has to have an objectively unreasonable position to get their fees paid, or one of the other factors, or several of the other factors have to balance out in favor of fee shifting. So is it objectively unreasonable for Triller Fight Club to come after potential piracy? No. But is it objectively unreasonable for Triller Fight Club to come after H3 Podcast? Probably objectively unreasonable. Probably in favor of fee shifting for H3, in my opinion. But the parties are going to argue it, and the Triller Fight Club people are going to say something along the lines of, this looked like legitimate piracy to us. He posted a copy of the fight, the heart of the fight, to an unlisted YouTube channel where you could get the unlisted address because he showed it on stream, and then he used it to make his fair use. And the H3 podcast is going to say, no, that was all one transaction or occurrence. That's how you do this, is you put a backup copy someplace so you don't lose your copy. And that's a legit thing. You're allowed to make a copy in order to make a fair use. So it's going to be a fight over whether they get their attorney's fees, and they're going to spend more than $25,000 on that fight alone, let alone the actual merits of the copyright case. So it's possible they're going to lose more than $25,000. So why not just pay the nuisance fee because it is economically efficient? I know it's not fun. It doesn't feel good to pay a copyright troll or a party who you disagree with their position, it doesn't feel fun for me to be in a dispute with my landlord right now and considering paying some amount of money to make it go away, even if I feel like I owe them nothing. So you consider what it's worth, your free time, your stress, your potential to lose more money to paying your attorney or to losing the case or something. You balance all of these things, and sometimes you do pay the money, even though it feels wrong. That's just the reality of lawsuits. It's sad in some way, but go ahead and propose a better system. I'm waiting. I would love to hear a better system. I would help influence and implement such a system if one could be had. Otherwise, using a reasonableness argument at some level and the parties argue over it means you have to pay the attorney to argue for you, to draft things and research things and make your case. And I don't know how you do it unless you're going to have the government pay attorneys to argue things for both sides in civil cases, which that's not going to fly in the US. You know that. I mean, that's pretty obvious to me. So I don't know how you solve that problem of having to pay some kind of nuisance fee. But I'm more concerned about the question of, one, taking the settlement money from YourEXTRA and De Los Santos and then returning it and suing anyway when you offered an amnesty program. But they seem to have a basis for that if their accusation is that it was more than just an illegal view. And then asking the H3 podcast to pay $900,000, but then say they paid more in a public statement. That seems right there on the edge of the line of legal, might be unethical. Again, I don't know for sure. It just seems really sketchy. And so I'm calling it shenaniganery. But you tell me what you think in the comments below. Thanks for watching. Special thanks to our top supporters in November: John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Torpedan, ShadowTycho, Earthbound Star, PureMagma, Drew Hart, TechTechPotato, Eric Tams, and the Blood-Soaked Survivors. You can support Lawful Masses on patreon.com/ljfrench, sponsors.com/law, through YouTube membership, and through Floatplane subscriptions. Join me for our weekly production live stream on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Eastern US time. I hope everyone has a great week. I love you all. Bye.